Hello everyone. I'd like to call this meeting of the Select Special Committee on Real Property Rights to order and welcome everyone in attendance. My name is RJ Sigurdsson, MLA for Highwood and chair of this committee. I'd ask that members and those joining the committee at the table introduce themselves for the record, and then I will call on those joining in by video conference. We will begin in person to my right.
Thank you, Chair. MLA Brad Rutherford.
MLA Garth Rosewell.
MLA Nicholas Milliken, Calgary Curry.
Tanny Howe, Fort McMurray Wood, Buffalo.
MLA Dave Hansen, Bonneville, Cold Lake, St. Paul.
Peter Doby, I'm the Farmers Advocate and Property Rights Advocate for the great province of Alberta.
Honorable Marlon Schmidt, ECA, MLA for Edmonton Gold Bar.
Good afternoon, everyone. Chris Nielsen, MLA for Edmonton Decor.
Bonnie Govindarajan, Parliamentary Council Office.
Good evening, Nancy Robert, Clerk of Journals and Committees.
Warren Huffman, Committee Clerk.
Excellent. We will now go to those joining us virtually. We will start with MLA Neudorf. Please go ahead.
He's muted. Maybe
Well, he think MLA Neudorf is still muted. There we go. Excellent. And next we have MLA Van Dyken.
Yeah, good evening or good afternoon. Glenn Van Dyken, MLA for Athabasca, Barhead, Westlock.
And just as a double check, I don't see any others that have joined us virtually, but I'll just pause briefly to make sure we haven't missed anyone. Hearing no one. For the record, I would just like to note a few substitutions for tonight's meeting. We have MLA Dack for MLA Sweet and MLA Neudorf for MLA Fry. A few housekeeping items to address before we turn to the businesses to hand. Please note that the microphones are operated by Hansard staff. Committee proceedings are live streamed on the internet and broadcast on Alberta Assembly TV. The audio and video stream and transcripts of meetings can be accessed via the Legislative Assembly website. Members participating remotely are encouraged to have your camera on while speaking and your microphone muted when not speaking. Remote participants who wish to be placed on a speakers list are asked to email or send a message in the group chat to the committee clerk, and members in the room are asked, as always, to please signal the chair or committee clerk. Please set your cell phones and other devices to silent for the duration of the meeting. Moving on to item 2, approval of the agenda. Are there any changes or additions to the draft agenda? I see MLA Rutherford.
Thank you, Chair. I was just looking to add, probably after section 3, just a section where we can potentially review additional acts or have a section for that discussion.
I do believe that would be an add to a review of scope to the agenda. At this point in time, we'll make sure that gets added in. I do believe the committee clerk, or we'll just, are you going to briefly, yeah, there we go. That the agenda be amended by adding scope of review prior to research services. Is there, of course, any additional comments that you'd like to make to this, or?
Just briefly at this time, because the debate for that will be later on, but I think it's self-explanatory, just a conversation at that point to discuss any additional acts that might be brought in for review.
Excellent. Before we get into debate on this, of course, as we have motion 52041 in play, we just want to make sure that we can proceed with this. So prior to getting into discussing this, of course, we have to vote to allow whether we can move into the discussion portion. So all those in favor of allowing this amendment in person, please say aye.
Aye.
All those in person opposed to allowing this amendment, say nay. Online, all in favor, say aye.
Aye.
Online, all those opposed, say nay. Hearing none, that motion is carried. We can now proceed to discussing and then, of course, voting, if so, on this motion. Please go ahead, MLA Rutherford.
Thank you. I think the agenda will be now amended, but my comments will still be just rather brief to what I had said before, Chair. That at that section of the agenda, we will bring up the additional acts, potentially.
Excellent, thank you. At this point in time, of course, we will have to vote on the agenda if amended, but I will just pause to see if there are any additional changes or additions to the draft agenda. If not, would somebody like a motion to approve the agenda as amended? I see MLA Hanson. To move the agenda as amended, all in person, all those in favor, please say aye.
Aye.
In person, all those opposed, say nay. Online, all those in favor, say aye.
Aye.
Online, all those opposed, say nay. Hearing none, thank you. That motion is carried and the agenda as amended is adopted. Next, moving on to approval of minutes. Next, we have the draft minutes of our February 16th, 2022 meeting. Are there any errors or omissions to note? If not, would a member like to make a motion to approve the minutes? I see MLA Milliken. Moved by MLA Milliken that the minutes of February 16th, 2022 meeting of the Select Special Committee on Real Property Rights be approved as distributed. In person, all those in favor, please say aye.
Aye.
In person, all those opposed, say nay. Moving online, all those in favor, please say aye.
Aye.
Online, all those opposed, please say nay. Thank you. That motion is carried. At this point, I will just pause briefly. We've had an additional member join us here this evening. Could you please just introduce yourself, state your name for the record?
Thank you. Good evening. Lauren Dack, MLA for Edmonton McClung. Thank you, Chair.
Excellent. Thank you. We are now moving on to 4 research services.
Scope of review, amended agenda.
Oh, sorry, and I apologize. We did amend. Apologize, just one sec briefly. We're now moving on to the item review of scope as amended. I apologize to the committee members. At that time, I see that MLA Milliken has signaled me. Please go ahead. I apologize to the committee.
Yeah, I think this was submitted correctly. I move that the Select Special Committee on Real Property Rights expand its review to include the Surface Rights Act because the committee has determined, based on its consultations, that doing so is necessary to ensure the completeness of its review. And it looks like it's up there.
Excellent. It is on the screen for everybody to review. We'll move into a discussion. Do you have any additional comments?
I have a few quickly prepared comments. Essentially, it's fair to say from everybody who was at the public engagements that I think that on a number of occasions, different landowners and Albertans generally, pretty much across the province, did voice some concerns with regards to surface rights issues. Old surface rights boards, timelines, and therefore I think that it's probably wise to bring the Surface Rights Act into the scope for the purposes of our deliberations.
Excellent, thank you. Is there any further discussion? I see MLA Nielsen. Please go ahead.
Yeah, thanks, Mr. Chair. Yeah, I would certainly agree. That was definitely one of the things that we heard during our consultations. I think we've also heard other concerns from Albertans around, some of the issues they're facing, problems, thoughts, things like that, how to move forward. I think would be, I guess, well served for us, I think, later as a committee to potentially at least have a really open conversation, that way we're not painted into a corner in terms of what we can and can't do. So I would suggest that I have a sub-amendment to this one.
Just pause briefly. And based on 52041, just as a note, in order to allow this amendment, it would have to be to the will of the committee to allow this amendment. So at this time, before we proceed, MLA Nielsen, I will ask the question to the committee whether we at this time allow this amendment to proceed in person. All those in favor, please say aye. Aye. In person, all those opposed, please say nay. Nay. Moving online, all those in favor, please say aye. All those opposed, please say nay.
Nope.
That is defeated. We're moving back to discussion on the motion as proposed by MLA Milliken. Is there any other comments or to the motion that is on the screen? Seeing none, I will call the question. All those in favor of the motion as proposed by MLA Milliken, in person, please say aye. Aye. In person, opposed, please say nay. Moving online, all those in favor, please say aye.
Aye.
Aye. Online, all those opposed, please say nay. Thank you. That motion is carried. Is there any further discussion on review of scope at this time? Seeing and hearing none, we will move on now to research services. There is a summary of oral presentation at public meetings. Honorable members, Legislative Assembly Office Research Services provided the committee with 2 research documents which were posted on the committee's internal website. The first is a summary of oral presentations made during the public meetings held by the committee earlier this year. At this time, I would like to invite Dr. Sarah Amato from LAO Research Services to provide an overview of this report.
Good evening. I hope you can hear me. So the first document I'll talk about is the summary of oral submissions made at the public engagement sessions in February, March, and April in Edmonton, Edson, St. Paul, Medicine Hat, Fort Macleod, Hanna, and Eckville. The document is a summary of submissions made by, or oral presentations made by 62 members of the public. You'll find the executive summary on page 3 and 4 of the document. And there you'll see some of the issues that were raised by members of the public grouped into 4 categories. And I'll just briefly go over them. So the first was the adequacy of legal remedies available to landowners. And grouped under this issue are a variety of concerns that were expressed related to feelings that current legal remedies need improvement. So there were issues raised concerning the provisions of the Expropriation Act, expropriation information sharing and notification processes, cutting red tape, the Land and Property Rights Tribunal, and compensation and lack of enforcement. The second category is expansion of real property rights and constitutional protections. Most presenters recommended the expansion of real property rights and discussed constitutional protections for property rights. Some also discussed expansion of rights for landowners adjacent to development, adverse possession, grazing leases, carbon capture and storage, and the Geothermal Resources Development Act. The next category was additional legislation. And here there were concerns regarding the Wildlife Act, the Historical Resources Act, the Species at Risk Act, and the Special Areas Act. And the final category is just grouped under other comments. And here there were concerns regarding government monitoring activities, Indigenous land and treaty rights, and rural crime. Thank you.
Excellent. Thank you so much for that review, Dr. Amato. At this point in time, I will just go back to the committee for any questions in relation to your presentation. Are there any questions at this time? Oh, seeing and hearing none. Excellent presentation. We move on to the summary of issues and proposals. The other document is a summary of the issues and proposals from stakeholder and public submissions and presentations to the committee during the course of its review on real property rights. I would like to again invite Dr. Amato to provide an overview of this summary. Please go ahead.
So I hope you have a copy of the issues and proposals document, and I'll just once again provide a very high-level summary of it. So Section 1 is the introduction. Section 2 suggests how to use the document. Section 3 is an executive summary, and the issues and proposals themselves are listed under Section 4. I'll just note for you that in Section 4 there's a notes column, and the notes column contains references to additional information provided by submissions, oral submissions or written submissions where applicable. So I will turn to generally how to use the document. And I will just ask you to please note that it is intended only to assist the committee as it engages in the deliberation process. Committee members can decide the order in which to consider proposals and may indeed wish to pursue other issues related to real property rights that are within the committee's mandate, but were not brought forward by stakeholders, organizations, or members of the public. Please also note that although the issues documents includes recommendations pertaining to Bill 206, Bill 206 was removed from the order paper on February 21st, 2022. So turning to the executive summary, I'll just go through it. You'll find it on pages 2 and 3, and you'll find there that all issues and proposals are grouped under 7 main headings, and I'll just go through them at a very high level. So the first are recommendations relating to legal remedies for real property owners. The second is recommendations relating to expansion of real property rights and individual constitutional protections. The third category is recommendations abolishing the law of adverse possession. The fourth category are recommendations related to the adequacy of expropriation processes provided under the Expropriation Act. The fifth category is recommendations relating to Bill 206. And once again, Bill 206 was removed from the order paper on February 21st, 2022. The sixth category are recommendations pertaining to the Alberta Bill of Rights, the Alberta Land Stewardship Act, Expropriation Act, Land Titles Act, Law of Property Act, Limitations Act, or Responsible Energy Development Act. And then the second category is a bit of a catch-all for additional recommendations on real property rights in Alberta. And you'll notice there that there's a range of recommendations from those relating to the Municipal Government Act, subsurface formation and carbon sinks, through to freehold mineral rights in the Geothermal Resources Act, repealing the Calgary Metropolitan Regional Board regulation, and recommendations related to the preservation of trees, ecosystem goods and services, wildlife management, grazing leases, the Wildlife Act, and reviewing the Special Areas Act. So that's, again, a high-level summation. I hope it's somewhat useful, and I'm happy to answer any questions.
Excellent. Thank you so much for that review. I will again pause and go to the committee for any clarifying questions for Dr. Amato. Oh, sorry, MLA Milliken, please go ahead.
I just want to take an opportunity and thank you, Dr. Amato, and of course all of Research Services, because I read both of these documents thoroughly and I was very impressed. So I just wanted to take an opportunity to put on the record as thank you.
Excellent. Is there any other questions or comments at this time? On behalf of the committee, Dr. Amato, and to all your staff for putting this together, thank you again for these great presentations and summaries of the committee work. So thank you again. Next, we are moving on to next steps in the agenda, A, deliberations and recommendations. Now, before we begin our deliberations process, I'd like to take a moment to give an overview of the work the committee has done. The committee was struck on March 22nd, 2021, and began its review by striking a subcommittee on committee business, clarifying its scope of review, and hearing technical briefings from government ministries. The committee contacted First Nations and Métis settlements across Alberta about hosting the committee. There was a handful of groups who expressed interest. However, no meetings happened. The committee received written and oral submissions from stakeholders and the public, and the committee also held 6 in-person public meetings around the province and a virtual meeting from Edmonton here to hear from Albertans. We will now take all of that information into consideration as we begin our deliberations related to the committee's mandate review of real property rights in the province. To assist us with this, the committee requested that the Ministries of Agriculture, Forestry and Rural Economic Development, Justice and Solicitor General, Energy, Environment and Parks, and Indigenous Relations to provide technical support during our deliberation process. Joining us at the table today, we have Mr. Peter Dobby, Farmers Advocate and Property Rights Advocate. Thank you for joining us today. I would state for everyone's information that we are considering the recommendations that we would like to include in our report to the Assembly. I would remind the committee that we are required to report back to the Legislative Assembly by June 30th, 2022. Under Standing Order 52041, notices of substantive motions were due to be received by May 20th, 2022. And notices of amendments to those motions were due on May 24th, 2022. The Legislative Assembly office staff have been able to assist committee members with the drafting of motions and to distribute proposed motions on the internal website. These motions are on notice for today's meeting as well as tomorrow, so we can address them in an order that works for our deliberations. With that, I would like to open the floor to begin deliberations, and I see MLA Rutherford. Please go ahead.
Thank you, Chair. I'll just start off by moving a motion. And so that I move that the Select Special Committee on Real Property Rights recommend that the Surface Rights Act be amended to A, reduce the burden of legal costs incurred by an owner or occupier who appeals a compensation order or requests a review of a rate of compensation. B, establish an arbitration process in respect of disputes arising between an owner or occupier and an operator. And C, establish rules or a process that reduces the legal costs incurred by an owner or occupier who appeals a decision of the Land and Property Rights Tribunal to the Court of Queen's Bench. And now that is up on the screen for everybody. Just some rationale around that, if I could, Chair.
Please go ahead.
Boy, thank you. Throughout the process on this committee, I think we heard consistently from Albertans that they did not feel as though they had adequate legal remedies available to them, and when they were deprived of use of their property or land. The primary source of this belief seemed to stem from interactions with utility, oil, and gas companies. And when landowners came into conflict with them. We heard this especially at the St. Paul public meeting, where many farmers and property owners brought up issues around hearing timelines, notice of hearings processes, as well as costs associated with pursuing any legal action. There was a concern and frustration from these property owners on how companies have deeper pockets than they do. They're able to pay lawyers, keep lawyers on retainer, and they felt as though they were put into an unfair situation, and that this recommendation would assist in alleviating that, especially in drawn-out legal disputes where property owners are put, I think, at a disadvantage against companies that can hold out longer with legal fees and retain lawyers longer and draw this process out. So that's my rationale, Chair.
Excellent, thank you. Is there any further discussion on this? I see Honorable MLA Schmidt, please go ahead.
Thank you. So a couple of questions to Mr. Rutherford, who's bringing forward this motion. First of all, can you expand a little bit on what your intent was behind Section B in this motion, establishing an arbitration process? My fear is that this will be another hoop that landowners have to jump through before they can actually go to the Land and Property Rights Tribunal to get a decision. Because what we've heard clearly from landowners all across the province was that the oil and gas, or the usually oil and gas companies, but industrial proponents, those kinds of people who are seeking to conduct activities on landowners' property, put them through the ringer. You know, they try to negotiate a deal, they drag out the process, those kinds of things. I'm just wondering if the arbitration process will actually improve landowners' ability to get a fair hearing and get a fair settlement, or will it just be another hoop that landowners have to jump through before they can get a fair hearing and a fair settlement?
Well, I appreciate the question, Honorable Schmidt. No, and it is not intended to be an additional hoop. It is not intended to add additional burden. The issue around arbitration is that companies have gone straight to legal action. Arbitration is supposed to be there to help alleviate costs.
So will we be recommending is this a mandatory step, I guess, that I'm asking? Or is this something that landowners and operators, industrial project operators, can voluntarily agree to, or just, I guess, arbitration is a very broad term that means many things in very different contexts. We are recommending setting up an arbitration process, but absent any kind of boundaries or specifications as to what kind of arbitration process we're proposing here, I think we're asking more questions than we're answering.
And it's a fair concern, and I think on the record of this committee, I mean, we can obviously express that. This is about streamlining that process. I think laying out exactly what that arbitration process looks like is not what I want to be able to put into this recommendation. What I want to be able to suggest to future legislation is that we need a streamlined process that can help landowners and property owners through legal disputes and have it be just a more streamlined mechanism. As I laid out in the rationale, the costs that can be incurred, the legal fees that can be incurred, and my intention here is to simply try to find a process that can settle these disputes in a quicker fashion.
And one final question then, if I may, on Section C. So we're recommending to establish rules or a process that reduces the legal costs incurred by an owner or occupier who appeals a decision of the Land and Property Rights Tribunal to the Court of Queen's Bench. Now, it's more than just owners and occupiers who appeal decisions of the Land and Property Rights Tribunal, right? Right now, the town of Canmore is considering an appeal that the Land and Property Rights Tribunal made regarding the Three Sisters Mountain Village project to the Court of Queen's Bench. Is our intention to provide rules and processes that reduce the legal costs for municipalities, recognizing that municipalities often are strapped for resources and don't necessarily have, or would benefit, I guess, is more fair to say, from a system that reduces their legal costs as well?
It's not the direction I considered in the motion around municipalities. I was considering landowners as well, basically, and to be able to help them with the legal costs and to streamline that process for them. I know I'm repeating myself on that, but I'm trying to keep it into the simplest terms in the recommendation of what we would like to see. in future legislation.
Yeah, and also if I could just say, I don't think during the Sure, yeah.
Just to make sure, are you finished, MLA Rutherford?
Yes.
Okay, thank you. Sorry, MLA Milliken, you are next to speak. Please go ahead.
And just to bring it back, I think that throughout this process, the recommendations that we've been looking at have been in large part due to what we heard through public engagement. I don't think we heard too much issues or anything along the lines of municipalities and whether or not they're having issues with regards to paying for legal costs, or if they feel like perhaps, because I think that the original intention of this, and I wouldn't obviously presume the will of the room or anything like that, was to ensure that those individuals who felt like they were fighting something that was larger than them or had deeper pockets, is I think a word that I heard a few times, that was the issue. So I think that's just the idea, is to allay those kind of fears. So.
Thank you, MLA Milliken. Next, we have MLA Dack. Please go ahead.
Not to get off the subject, I could defer to MLA Schmidt if he wants to carry on the conversation on the one topic.
I wouldn't mind, Mr. Chair, if I could. So with respect to Mr. Milliken's discussion, I will remind the committee that we did hear from a councillor from Starland County at the meeting in Hannah who was talking about these very issues, challenges dealing with the regulatory system, industrial operators, those kinds of things. And I think that it might be fair to capture concerns of municipalities and their concerns around land and property rights tribunal as well. Just a friendly suggestion for your consideration.
I see MLA Milliken. Please go ahead.
Yeah, just to respond, again, I'm only commenting with regards to C, which was the issue that you brought up, which had to do with the legal cost aspect of it, and I don't think we heard anything with regards to the municipality's views on that. So, but you're right, we did hear from a councillor on some somewhat related issues under property rights, for sure. So, appreciate it.
Is there any other questions, comments in relation to the motion? I see MLA Nielsen. Please go ahead.
Thanks, Mr. Chair. I guess the good thing with Hansard, as the government considers legislation, they can go back, read some of the discussion we were having, and hopefully maybe that's just a consideration then that they'll think about when they're potentially drafting legislation. Of course, I'd never assume that the government will accept all our recommendations and whatnot, but I guess at the end of the day, I mean, there's no reason for the motion not to proceed. And vote and for members to vote in favor. And again, hopefully we'll be able to look at some of those smaller municipalities like we heard, and they'll be considered when thinking about it. So.
Next I have MLA Dack. Please go ahead.
Thank you, Chair. Just briefly wanted to add my comments to the record on item B, arbitration, with respect to comments made previously by the honourable member for Edmonton Goldbar. I think the point is well taken that the arbitration process, while not prescribing in detail to the legislature what the regulations might be, should be noted whether it's going to be a mandatory process or not. And I think that is not overly prescribing to the legislature. I think it's important to let the legislature know this committee's intent, because it is a very important element, whether that will be a mandatory or an optional part of the process. If one, as a landowner, could skip right to the courts, if that option existed, it's a very important element to be clear, and I think it's important for this committee to make its notions clear. And I would, maybe my preference, that the arbitration process be a step that would be optional, not necessarily a mandatory process. And I'm not sure if the committee is interested in pursuing that or commenting further on it, but I think it's not beyond the scope of this committee to tell the legislature clearly whether that arbitration process should be mandatory or optional.
Excellent, thanks. Is there any further discussion on the motion on the screen? Seeing and hearing none, we'll now move on this. So the motion as proposed by MLA Rutherford, all those in person in favor of this motion, please say aye. Aye. In person opposed, please say nay. All those in favor online, please say aye.
Aye.
Aye. Online, all those opposed, please say nay. That motion is carried. Next, I see MLA Roswell. Please go ahead, MLA Roswell.
Yes, I would like to move a motion on behalf of MLA Van Dyken.
Please go ahead.
Okay. MLA Van Dyken to move that the select special committee on real property rights recommend that A, the government review the average period of time the Land and Property Rights Tribunal requires to resolve a matter referred to it under the Surface Rights Act, and B, the Surface Rights Act be amended to enable the Lieutenant Governor and Council to prescribe timelines within the Land Property Rights Tribunal must resolve disputes brought before it.
Excellent. I do believe that motion is now up on the screen, so if you'd like to move with your rationale, please go ahead.
Yeah, we've heard quite a few complaints about delays on, the surface right boards before that, and now that it's been amalgamated, the tribunal as well. And I think it'd be nice to review how much time it takes and try to get it sped up, and then also to give the governor and council opportunity to prescribe that. I just think it's, we heard that quite often throughout our tour and presentations and stuff. So I think that's the main rationale behind the recommendation.
Excellent, thank you. Is there any discussion on the motion as proposed by MLA Roswell? I see MLA Nielsen. Please go ahead.
Yeah, thanks, Mr. Chair. Appreciate the motion coming forward. Obviously, reviewing timelines on a somewhat regular basis is always a good thing. You never know when things are changing. Something new comes in, something gets out of date or whatever. So it's good to review those. Maybe I would suggest when it comes to timelines, rather than possibly having them in regulations, we might even want to consider legislation around that. That way they're firm, there's no ambiguity about it. So hopefully, maybe the government might consider those kinds of things moving forward. And of course, if there is a tribunal, it's key that tribunal is properly resourced. If it's not, we're simply going through the motions, and I think that does a disservice to landowners. So hopefully that is considered too, should that be put together. So I'm happy to support the motion going forward, and certainly would encourage others to do the same.
Excellent. I will just briefly pause at this time. Of course, we've had another member of the Assembly join us here this evening. Please, if you would like to just introduce yourself to the committee.
Todd Lowen, MLA Central Peace.
Excellent. Thank you. Next on the speaking list to this motion, I have MLA Van Dyken. Please go ahead.
Good, thank you, Chair. And I'd just like to reiterate that, we have the Property and Land Rights Tribunal established. Not quite a year since it's been established, and I think it's imperative that we get a good baseline understanding of what's acceptable in these decisions and these undertakings. The government has put a substantial amount of resources, money towards reducing the backlog with regards to Surface Rights Board history of cases, and so I just feel that it's important that we recognize that being a relatively new entity, the Property and Land Rights Tribunal, that we try and understand what would be an acceptable expectation of timelines and try and move that in a direction where that can be an expectation going forward.
Excellent. Thank you, MLA Van Dyken. Is there any further discussion to this motion? I see MLA Hansen. Please go ahead.
Yeah, just a quick comment, and just to kind of support what Mr. Nielsen was saying, that, this is just a recommendation to government, and if it requires changes in legislation, that they would probably throw that into one of the wonderful omnibus bills that we like to put forward. Yeah, but just wanted to reiterate that, yeah, this is just a recommendation to government, and whether they put it into regulation or legislation is further study. Thanks.
Is there any other further discussion to this motion? Seeing and hearing none, we will call the question on the motion as proposed by MLA Roswell on behalf of MLA Van Dyken. In person, all of those in favor, please say aye.
Aye.
In person, all of those opposed, please say nay. Moving online, all those in favor, please say aye.
Aye.
Aye. Online, all those opposed, please say nay. That motion is carried. Moving on, I see Honorable MLA Schmidt, please go ahead.
Thank you. I'd like to move a motion, if I could, please, Mr. Chair.
Yes, please proceed.
I move that the Select Special Committee on Real Property Rights recommend that the minister consider commodity prices for oil and gas as a factor in its determination of the mandatory closure spend targets under the government's liability management framework.
Excellent. We'll just wait for that to get up on the screen and then. Excellent. That is up on the screen. Please proceed with your rationale.
Really good. Thank you, Mr. Chair. So, I mean, as all committee members are aware, we heard from landowners all across the province significant concerns around oil and gas companies not dealing with their remediation and reclamation liabilities in a timely fashion. I know that this is a problem that the government has plagued the government for a really long time. I'm really pleased that the government has amended their liability management framework to require mandatory spends, but I think that everybody can agree that that's probably not enough to tackle the problem, and especially right now when we've got oil trading at over $100 a barrel, gas is $9 a cubic foot. Now is really the opportunity to capture some of the value that is being generated by these oil and gas companies and dedicate it towards dealing with these remediation and reclamation liabilities in a timely fashion. And so I would urge that all committee members vote in favor of this and respond meaningfully to the concerns from landowners that we heard about the timeliness of remediation and reclamation.
Excellent. Thank you for that. Emily Schmidt, is there any discussion to this motion? Oh, sorry, MLA Milliken, please go ahead.
Just very briefly, and just note that I was looking through some of the notes that I'd made and some of the documents that were prepared by research services, and I couldn't find a mention that had to do with the government's liability management framework. And so I just think that perhaps we may want to consider ensuring that our recommendations kind of stick to the original goals, I think, of this, and I would just go so far as to say that I think that this tangentially at best, I think, could arguably be maybe within the mandate, but I just don't see it, and we never really heard on it. So for those reasons, I would probably just say that I think they're outside the scope, and I'd probably just recommend that people don't vote in favor of this.
Is there any further discussion on this motion? Sorry, go ahead, MLA Schmidt.
Ooh, well, I think landowners will be upset to hear that government members voted against this on a technicality. I think it's well within the scope. We certainly heard from landowners all across the province that this is an issue. It's a shame that government members are going to use some technical definitions of the work that the committee is doing to excuse themselves from tackling this significant issue.
Is there any, sorry, I see MLA Hanson, please go ahead.
Yeah, no, and I beg to differ with you, Mr. Schmidt, but I deal with this out in my constituency quite often, but at no time has anybody recommended that we tie it to the prices of oil and gas. You know, we have supported through legislation with the gas operators, giving them a break, I guess, on royalties and that kind of thing to help them survive the downturns. But as a landowner, I've got a gas well on my own property. We renegotiate that every 5 years. It's something that is part of the contract that we sign with the oil and gas companies. And although I realize that there are issues that some people are having in some areas of the province, especially with, some of the companies not paying and even their linear taxes to municipalities. But that's not the mandate of this committee. We were to take recommendations based on what we heard from the public in our public submissions, and in nowhere did I see anything to do with tying it to the oil and gas prices.
Next, I have MLA Dack. Please go ahead.
Mr. Speaker, I think it's very clear that the discussions that we heard, as is from this committee, from the public, was that they're extremely concerned about the responsibility or lack thereof of corporations from paying their appropriate share of fees and taxes, and also that they would be coming cap in hand to landowners or municipalities when times are tough and looking for leniency or looking for a reduction or a delay in their payments that were due. It's a two-way street, in my view, Mr. Chair. When we have royalty windfalls, or we have the prices of our resources, or oil and natural gas, reaping, and corporations are able to reap very, very significant profits, then I think the government and the public has a right to say, look, times are good now, we are going to recapture some of that and pay some of the costs that have been neglected over the time periods by companies that have opened these wells. So the public very clearly said they want a solution to it. We're offering one, and I think it's a fair one. It's a two-way street.
Any other speakers to the motion? Seeing and hearing none, I will call the question on the motion as proposed by Honorable MLA Schmidt. In person, all those in favor, please say aye. In person, all those opposed, please say nay.
Nay.
Online, all those in favor, please say aye. Online, all those opposed, please say nay.
Nay.
That motion is defeated. Next, I have MLA Milliken. Please go ahead.
I would also like to move a motion surrounding constitutionalization of property rights. So the wording would be as such. Member Milliken, to move that the Select Special Committee on Real Property Rights recommend that the Ministry of Justice and Solicitor General, identify the textual changes to the Constitution of Canada that would be required to constitutionally entrench the protection of an individual's rights in respect of real property located in Alberta. B, identify the process and associated steps that would be taken to effect the changes identified in Clause A, and C, report its findings to the Legislative Assembly by July 15th, 2023. Any comments?
Clerk already has that up on the screen, so please go ahead with your rationale.
Yeah, I think that we heard from a lot of Albertans with regards to their desire to have property rights, real property rights, more strictly entrenched and protected. I think that it was Ross Ford on, I believe, April 12th that mentioned that he was recommending, or they wanted us obviously to recommend that the government constitutionally enshrine property rights both federally and provincially. We actually managed to hear from several levels of government on this, including in support of constitution of entrenching property rights. It was Damien Currick, a federal MP, and he stated that he encouraged the committee to hear from the many experts on U.S. constitutional law that he has no doubt would be happy to share their findings with the committee. Canada's acknowledgement of property rights falls behind its peers in the democratic world. And the reason why I actually quoted him on this point is because of the fact that I think it's been pretty well established anyways, I think, or arguably established, that Canada's constitution in many times has been described as an outlier among liberal constitutions. And that last one, actually, I'm just going to give a shout out to my own constitutional law prof from way back in the day, an individual by the name of Dwight Newman. And then I'm no constitutional lawyer, but I know there's amending formulas and things of that, the general formula, unanimous, things of that nature to potentially do that. And I think going back to Dwight Newman, I think in recent writings concerning the possible use of the bilateral amendment of amending formula to achieve property rights clauses, in particular provinces that are currently seeking them. So sometimes it's just specifically for the province, sometimes it would be something for the whole country. But I think that from what we heard throughout all of the engagement on this topic specifically, I think there was a resounding yes to trying to see if there was some way to further entrench the rights of Albertans.
Excellent, thank you, MLA Milliken. Next, I have MLA Dack. Please go ahead.
Mr. Chair, on this issue of entrenchment, I'm not sure how loud those voices were about seeking to change the Canadian Constitution by vehicle of this particular committee and the legislative recommendations we might make. But I mean, we all know that the province can't change the Canadian Constitution, and while this government, current government, really likes to be focused more on federal matters than Alberta matters in many cases, we deserve a government here that's focused locally on matters that can be achieved at hand, and we've seen this repeatedly, that the government's looking to deflect. I'm not certain that this is what we should be recommending to the legislature. Another impossible measure that the province can't take on its own is simply begging the federal government for something that we don't really have a lot of call for from my reading of the representations that were made to the committee. So I'm not supportive of it.
Thank you. Next, for speaking, I have MLA Milliken. Please go ahead.
And just in friendly response, I would give a quick shout out to Research Services for the documents that they provided. Rossford was only one individual from the 12th that brought it up. There was Nemeth on the 16th, Yorkman on the 16th as well of February, Lowry, Browen, Newton, Murfin, Young. This was throughout on the February 16th, on the 14th of April, on the 12th of April, virtually at every single committee. On the 13th, that's when the MP spoke out about those recommendations. There was also, with regards to potential proposals that were even produced, Murfin was one of them, Browen, Bjorkman, Lowry, McKenna, Newton, Currick, Young on the 14th, with regards to the government constitutionally enshrined property rights, both federally and provincially. So I think it was pretty clear from my experiences throughout the process of listening to Albertans. And again, I would just recommend that everybody, hopefully, will be willing to vote for this, because I think it encapsulates very clearly what we heard through public engagement with the province with regards to their desire to entrench their property rights constitutionally. And I think, again, I hope everybody votes in favor.
Any further discussion? Seeing and hearing none, I will call the question. All those in favor of the motion as proposed by MLA Milliken, in person, those in favor, please say aye. Aye. In person, all those opposed, please say nay. Online, all those in favor, please say aye.
Aye.
Aye. Online, all those opposed, please say nay. That motion is carried. Next, I have Honorable MLA Schmidt again. Please go ahead.
Thank you very much, Mr. Chair. Let me just quickly find the motion here that I wanted to bring forward. I will keep talking so that I'm not skipped over or passed over. Yes, right. So I move that the Select Special Committee on Real Property Rights recommend that the Responsible Energy Development Act be amended to specify the classes or types of persons that are considered to be directly and adversely affected, as that expression is used in that act, by an application or decision made under that act relating to the use of a body of water.
And that is up on the screen. Now, please go ahead with your rationale.
Yeah, so I think that's one of the things that really stood out to me in listening to the people who presented to the committee. And again, it is identified as an issue in the report that landowners want to be included in the regulatory processes that should be open to them, but they find that they aren't, because the definition of directly affected that is applied by the appropriate regulators is so narrow that people who feel they are directly affected or will be directly affected aren't considered such for the purposes of the regulatory processes that are open to them. And this is particularly underlined by issues relating to bodies of water. You know, we've dealt with issues related to projects that could potentially contaminate sources of water upstream or divert sources of water upstream of potential landowners. But those people downstream are not considered directly affected by the regulators that are charged with making decisions on these projects. And people are very frustrated with that state of affairs, and I think that by making this recommendation, we can make some significant advances in the regulatory processes by expanding the scope of people directly affected to better include people who are directly affected by these processes. Thank you.
Is there any discussion on this motion as proposed? Emily Hanson, go ahead.
Sorry, thank you, Chair. Just kind of a clarification. As an example, I would use, you know, Edmonton wants to rework or build a new water treatment plant. Do you consult with every city along the North Saskatchewan River in Saskatchewan through Manitoba to the Hudson's Bay? Like, where does this start and where does it stop, I guess, would be my question.
Well, as Mr. Hansen knows, the construction of those kinds of works that he listed as an example wouldn't be considered under the Responsible Energy Development Act. But, you know, there is an extensive legal framework behind the apportionment of water downstream. You know, Alberta has agreements with Saskatchewan, we have agreements with Montana, we have agreements with the Northwest Territories. There are methods in place for arbitrating those disputes between jurisdictions when it comes to water apportionment, but within the province of Alberta, there is nothing, right? People could potentially be directly affected, and they don't have a meaningful way to engage in these processes. So, you know, to Mr. Hansen's point, if we want to treat Alberta's own citizens with the same respect that we treat people in Saskatchewan, Montana, and the Northwest Territories, this would be a good place to start.
Thank you. Next, I have Emily Hanson. Please go ahead.
And if I could just add to that, so I guess my question there then, I mean, it opens up to the point where you may not be able to do any development at all. And I guess my question is where is this motion coming from? Is this coming from some specific presentation that was brought forward to us, or is this a political statement that you're trying to make?
Well, again, I would refer Mr. Hansen to the research documents that were provided that clearly indicate that people feel that they are being excluded from these regulatory processes. I'm using a body of water, I think, as a particular example of an area where people are excluded where they rightly have a place. And, you know, I don't think it's unrealistic to say that people will have potential significant negative impacts on bodies of water that they rely upon for a whole host of uses. And we need to recognize that one person's ability to use or impact a body of water, for example, does impact somebody else's availability. That doesn't mean that there will be no industrial development allowed. Of course, that's a ridiculous suggestion that I think Mr. Hansen is using to sink this motion. But I do think that there are overlapping demands on our water resources, in particular in southern Alberta, where we need a better system of arbitrating these disputes.
Thank you. Next, I have Emily Milliken. Please go ahead.
With respect, I don't have the answer here to this, but what I'm worried about is that what we might inadvertently be doing is perhaps creating some sort of new property right. As you know, use and ownership are two different things. It's the Crown that owns the water, so I'm just worried that we might be maybe opening the door to some sort of a new property right on this. So I think on that grounds, I think that goes well beyond any kind of a mandate that I think this committee was given. So just a thought.
Please go ahead, Emily Schmidt.
Well, with respect to the suggestion from Mr. Milliken, I am not suggesting that we are creating a property right. I am suggesting that we expand the use of directly affected, and I appreciate that, you know, all water is the property of the Crown, for example, but those, we do give what are colloquially called water rights to users downstream. And those need to be respected, I think. And by so narrowly defining adversely affected, we're causing negative impacts to those people who have water rights in the colloquial sense of the term downstream, and they aren't included here. So anyway, I hold out hope that I've been able to persuade my members, my friends from across the way here.
Emily Hanson, please go ahead.
Sorry, Chair, but I can't help but point out that this just looks like a political move. Specifically mentions the Responsible Energy Development Act. It doesn't talk about municipalities or anything like that. I just think it's part of the members' LEAP manifesto aspirations and.
Point of order. Point of order.
Just pause. Please go ahead with your point of order.
Well, under 23H, I, and J, I think the member is using language that's likely to cause disorder. He knows full well that I've had nothing to do with the LEAP manifesto. This has nothing to do with the LEAP manifesto. So I think that he should apologize and withdraw those comments. We are here. We are here to have a serious, respectful deliberation, and those comments aren't helpful to the process.
Thank you. Go ahead, Emily Rutherford.
Thank you, Chair. I don't think that this is a point of order. I think it's a matter of debate, and I don't think that those comments have reached a threshold of causing disorder, as the member has suggested. But I will leave it to you, Chair, to make a final ruling. Thank you.
What I will do is, at this point in time, I don't believe this is a point of order, but what I would caution is everybody to be clear on their words, make sure they relate to the work and the committee work that we're tasked to do here today. And please just try to ensure that your comments are directly related towards that. And Emily Hanson, please proceed. Go ahead.
Yeah, okay, thank you. No, that was the end of my comments. And, you know, for the interest of time, if I've ruffled feathers over there by pointing that out, like I said, my comments were that the motion was directly aimed at the energy development industry, and it's a consistent path that the opposition has followed through for many, many years, and the party has signed on to that, so I just assume that that was part of their political aspirations, so I will withdraw that comment.
Next I have MLA Nielsen. Go ahead.
Well, thanks, Mr. Chair. I guess I'll draw the parallel. We've just passed a motion to consider changes around the Constitution of Canada, which is not something that you know, Alberta can just arbitrarily do if it so chooses. It's going to require a whole lot of other work. So if we're ready to take on that and potentially any implications of that as well, I think looking at trying to determine who's directly or indirectly adversely affected within our own province certainly doesn't seem quite as daunting a task as trying to change the Canada Constitution. So, you know, I think if we can, as a committee, decide to take that on, we should be able to take this on. Our government should be able to take this on and do the work necessary to ensure that there's no unintended consequences.
MLA Schmidt, go ahead.
If I could respond to Mr. Hanson's comment as well, I mean, he knows that the Responsible Energy Development Act is one of the few acts that's under the scope of this committee. And we have, that's this is one of the ones that we can amend to directly and adversely, or make recommendations to what the definition of directly and adversely affected are. So that's why I'm bringing this forward. To his concerns that we are leaving municipalities and other potential users of water or people who are impacting water, it just so happens that I have another motion, and I hope that he votes to bring it forward, to allow me to bring it forward when the time comes. Thank you, Mr. Chair.
Any further speakers to the motion? Seeing and hearing none, I will call the question on the motion as it is up on the screen. All those in person in favor of the motion as proposed, please say aye. Aye. All those in person opposed, please say nay. No. Online, all those in favor of the motion, please say aye. All those opposed to the motion, please say nay.
Nay.
That motion is defeated. And next I see Emily Yao. Emily Yao, please go ahead.
Thank you so much, Chair, and I'd like to put forward a motion. And the motion is to move that the Special Select Committee on Real Property Rights adopt the recommendations of the Alberta Law Reform Institute set out in its final report on adverse possession and lasting improvements to wrong land dated April 2020, summarized generally as follows. A, that the Land Titles Act be amended to abolish any future claims of adverse possession. B, that the Law of Property Act be amended to provide that an assign does not have to prove the belief of the person who made an improvement. And C, that the Limitations Act be amended to provide for the following. 1, no limitation period for a claim to recover possession of real property. 2, no limitation period for a claim respecting lasting improvements under the Law of Property Act. And 3, the continuation of a 10-year limitation period for a claim to recover possession of real property in respect of a claim based on adverse possession that commences before adverse possession is abolished. And
that motion is up on the screen, so please proceed with your rationale.
My rationale, sir, is this is a pretty straightforward and common sense recommendation. We heard from constituents loud and clear right across the province on this very issue. In a nutshell, people do not care for the law that is known as squatters' rights. And we are really just following the recommendations of the Alberta Law Reform Institute, which was tasked with reviewing this law of adverse possession. And we would be passing a motion based on their recommendations.
Excellent. On the motion proposed by MLAO discussion, I have Emily Hanson. Please go ahead.
Yeah, thank you, Chair. And I'd just like to thank the member for putting forward a motion that actually reflects what we heard from the public. Thank you.
Next, I have Emily Nielsen. Please go ahead.
I had a little bit more time before I had to step up next here, but no, I appreciate Member Yao bringing the recommendation forward. You know, I'm prepared to support it with one very big caution that I would like to make sure that the government addresses as they go forward around how this is going to look. There needs to be very, very serious consultation with Indigenous peoples around this. We do know that there's, on occasion, it's been kind of used as a bit of an excuse to burn down Indigenous cabins. And so, you know, the government needs to move forward very carefully on this. The consultations need to be very, very robust with Indigenous peoples around the removal of adverse possession. So hopefully those are taken into consideration when they look at this motion and recommendation from the committee.
Next, I have Emily Dack. Go ahead.
Just briefly, as a long-term past real estate agent, I know that the industry members and the public involved with transactions that had property with adverse possession attachments to the title see this as a long-standing thorn in the side, and would be glad to see this anachronism gone. But I do echo Member Nielsen's comments that there are structures on lands that could be affected by this legislation that are owned or were installed or put up by Indigenous people who should be consulted with respect to how it might affect these properties, these structures. So it should be treated with care and due consideration. But the general thrust of this to get rid of the concept of adverse possession is welcome.
Is there any further discussion on the motion as proposed by Emily Howe? Seeing and hearing none, I will call the question. All those in favor of the motion proposed by Emily Howe in person, if you're in favor, please say aye. Aye. In person, if you're opposed, please say nay. Online, all those in favor say aye.
Aye.
Aye. Online, all those opposed say nay. That motion is unanimously carried. Moving on, next I have Emily Hanson. Please go ahead.
Thank you very much, Chair. I'd like to take this opportunity to propose a motion myself, if I may.
Please proceed.
And my motion would read that Mr. Hanson to move that the Select Special Committee on Real Property Rights recommend that the government examine its compensation process in respect of the expropriation of real property, specifically with respect to determining the fair market value of that property.
That motion is up. Please proceed with your rationale, Emily.
So rationale that this is something that's been really big in our area with specifically with the overbuild of electrical infrastructure in the province. It caused a lot of consternation with many of my farmers and landowners. So at the St. Paul Public Meeting Committee, members heard a consistent message from the public. I think you guys were all there. I tested positive that morning, so I had to miss the meeting right in my own hometown, unfortunately. But I did listen into it, and the transmissions line had gone through years before, and landowners are still feeling disrespected and put out by the process. So I think it's very important that we address this. They often felt bowled over by these utility companies, and folks in my area are scared it's going to happen again with wind turbines. So something I think that's very important that we address, because currently we do have a wind turbine project that's never been applied for, but it's causing division between neighbors because the landmen are out there trying to buy up and secure land for that process. So I think it's super important that we deal with this.
Thank you, Emily Hanson. Is there any discussion to the motion as proposed? Emily Nielsen, please go ahead.
I'm all for good government processes, right? At the end of the day, people should feel that they've been heard, their concerns have been addressed, and when indeed those things are being violated, that they get treated appropriately. So I'm happy to support this.
Any further discussion? Seems to be some consensus on this one, so I'll move to call the question on the motion as proposed by Emily Hanson. All those in favor of the motion in person, please say aye. Aye. In person opposed, please say nay. Online, those in favor, please say aye.
Aye.
Aye. And any opposed? Hearing none, that motion is also carried. Next, and I will actually move in the interest of fairness, I will move back over. Emily Nielsen, please go.
Wow, how about that? Now I don't even have the honorable name in front of my, so appreciate that. So I also have a motion, Mr. Chair, that
Please go ahead, Emily Nielsen.
I'm sure they'll find that up there, that the Special Select Committee on Real Property Rights recommend that the Auditor General conduct a performance audit of the Alberta Energy Regulator and Alberta Utilities Commission in respect to those public bodies' significant delays in adjudicating matters involving owners of real property that are brought before them under their respective enabling legislation.
And that is up on the screen, so please go ahead with your rationale.
Yeah, thanks. You know what?
Sorry, but is this motion in order? We just passed one that addressed exactly that from Mr. Van Dyken.
I'll just pause
a
briefly.
Clarification, if we could.
Just to get clarification, Emily Hanson and Emily Nielsen, I will pause briefly just to consult with the clerk to see if this is in order. So just pause briefly.
I think we've kind of covered it.
You're relating to the motion that was passed relating to the Land Property Rights Tribunal, correct?
Mr. Van Dyken's motion was presented in.
Just needed that for clarification. Thank you. It's fine. I've ruled that this motion proposed by MLA Nielsen is in order, so I am going to allow it. MLA Nielsen, please go ahead with your rationale and explanation.
Yeah, no, just pretty straightforward. You know, it's always good to audit these things, make sure everything's doing what it's supposed to do, people are getting treated the way they're supposed to be treating, any improvements that could be made. Those recommendations are therefore coming from a professional. There's no kinds of political motivations or anything like that. This is just about making sure that we have the processes, as we were talking a little bit earlier, that are good processes and that people can trust. And so I hope that members of the committee will support this.
MLA Hanson, go ahead.
And just for a point of clarification, Chair, so the only difference I see is that the motion that was passed recommends that the government do the audit and make the changes or recommendations, and this is asking that the Auditor General, who is an arm's length commission, looks into it. Is that basically the difference we're talking about? Okay.
Oh, sorry, just one sec. Please, I'm actually going to get a better explanation here, in the interest, I'm going to refer to Nancy Robert, who will comment on this for me. Thank you, Nancy.
Thanks, Mr. Chair. I think I realize they're both dealing with periods of time, but one deals with a regulator and a commission, the other deals with the Land and Property Rights Tribunal, which is different. So that's one of the differences. And then, of course, yes, the government reviewing and then the Auditor General, two different bodies. But I would say the main difference is the bodies that would be reviewed and the legislation also that would be reviewed. Okay.
Emily Hanson, does that clarify your questions? Do you have any additional comments?
Yeah, no, it does. That's fine, as long as we're, not just rehashing the same issue. I'm fine with that.
Excellent. Is there any further discussion on the motion as proposed by MLA Nielsen? Seeing and hearing none, I will call the question on the motion as proposed by MLA Nielsen. All those in favor of the motion as proposed in person, please say aye. Aye. All those in person opposed, please say nay. Nay. Online, all those in favor, please say aye. Online, all of those opposed, please say nay.
Nay.
That motion is defeated. We are moving on. Is there any further motions? I have MLA Roswell. Please go ahead.
Hi, yes, I'd like to move that the Select Special Committee on Real Property Rights recommend that the government develop a comprehensive compensation structure by which owners of real property are compensated if regulatory changes result in the removal of reasonable uses of real property. We did see some of these on our tour where people had bought land under the zoning that was there at the time to build their retirement home, and then it changed. And so there was and the person understood that, but they said, I'd like to be compensated because the value's been affected. And so that can be devastating financially for people, and some, some kind of made sense because they were in flood zones, but some left people kind of scratching their heads wondering, like, why was this changed? So I think we need to deal with regulatory issues that create problems for people. Changes.
So, thank you for that. Thank you for the motion and the rationale. Is there any discussion on the motion as proposed by MLA Roswell? Seeing and hearing none, we will call the question. The motion as proposed by MLA Roswell that is on the screen for everyone. All those in favor of the motion in person, please say aye.
Aye.
All those in person opposed, please say nay. Online, all those in favor, please say aye.
Aye.
All those online opposed, please say nay. That motion is carried. Next, we have MLA, Honor Roll MLA Schmidt. Please go ahead.
Yes, thank you, Mr. Chair. I'd like to move that the Select Special Committee on Real Property Rights recommend that the Environmental Protection and Enhancement Act be amended to specify the classes or types of persons that are considered to be directly affected, as that expression is used in that act by proposed activity, designation, release, decision, or any other matter as specified in that act relating to the use of a body of water. Now,
just before we get to rationale, I just have to consult with the clerk briefly, because I do believe that this may be out of order. So if we could just pause briefly, I'll consult, and then if it is ruled in order, we'll proceed with your rationale. Just pause for a second. I'll actually have the clerk's office address this, so give an explanation on the ruling with relation to this motion. Please go ahead.
Yes, just that this, our understanding is that this act was not included in the scope of the committee's review. So that would be the advice.
Excellent, thank you. And I do concur that when I'm looking at this right now, Honorable MLA Schmidt, that the act in which is relating to your motion under 93 is not included under the scope, so that would rule this out of order. Is there any additional motions to propose to the committee? Sorry, MLA Nielsen, go ahead.
Yeah, and of course, my colleague, I don't know if she's managed to join us online yet. Member Ganley?
And which motion are you related to, or referring to, MLA Nielsen?
Let me find that exact number for you, Mr. Chair. 90.
I would just comment that because the Oil and Gas Conservation Act is as well not under the scope, that this motion 90 is as well out of order at this time. Is there any additional motions? Seeing and hearing none, report of the committee to the Assembly. We are now on B. With the committee having now concluded its deliberations, we can proceed to directing research services to prepare a draft report containing the recommendations that the committee has approved this evening. At this time, I would ask that Ms. Robert provide us with a brief overview of this process and what the draft report will contain.
Thank you, Mr. Chair, certainly. I think most of you are fairly familiar with what final reports from committees such as this contain, but I'll just give you a very quick high-level overview. So the report will contain an executive summary that contains all of the motions that were agreed to this evening. It'll also contain, the committee mandate, so the motion that was passed, introductory remarks on real property rights, acknowledgements of ministerial and other officials who were involved in the committee's process, the work that was done, that the committee did with respect to consultation and review, and then again, the committee recommendations, but with some contextual information and rationale built in to each of the recommendations, and then of course appendices with lists of written submitters, oral presenters. If there are any minority reports would be added in the appendix as well. And that's basically it. I'm happy to answer any questions though. Thanks.
Thank you, Ms. Robert. Is there any questions from committee members? I see Emily Hanson. Please go ahead.
Yeah, thank you, and thank you, Ms. Robert. So one thing I'd just like, because I did bring up the question in the House, and I understand that the acts aren't included in our committee mandate, but one thing that we heard very, very common was access to public lands and enforcement of the Wildlife Act and the Public Lands Act. So I'm just hoping that that would be part of the discussion that's brought forward, because it was brought up at 3 different public meetings.
Ms. Robert, for a response.
Do you recall if you discussed it this evening when you were making recommendations?
Yes, I do recall that we did not discuss it because those two acts are not part of it, but it was something that we did hear quite consistently. And I'm not talking about any changes to the acts, just the recommendation or the ask from the public was the enforcement of existing regulations.
Typically, you know, when the part of the report that's just the consultation and review process will be more basic. The description will be, we went here, we heard from this. It might get into these were the general areas of discussion that we heard, but typically not. And then any other contextual information like that that you specifically want included, typically that would come up in a meeting such as this, and the committee would agree that, yes, we want this expressed. Even though we don't have a recommendation, we want this thought or idea or feeling expressed in the report. So.
If I could just, I didn't want to bring it forward as a recommendation because it would have been out of order because these aren't part of our act. So I'll just continue to pursue it with Environment and Parks on my own, and we can kind of forget about it. It's just, it was something that was brought up quite significantly at the public meetings.
In other committees, even though recommendations weren't made, the committees would specifically say, listen, we're not going to make any recommendations, but we do want to have this reflected in the report, and Research Services is happy to do that if the committee decides that that's what it wants, and so I'll just leave that there.
Sorry, Emily Nielsen, I apologize.
Oh, that's okay, Mr. Chair. And if I'm jumping the starting bell here, just let me know. Just because it was mentioned in the comments around the minority report, what would be the submission date on that?
I do have comments getting there, but we'll address just now the main committee process for the draft report at this time. Is there any further questions for Ms. Robert? I see Amalia Milliken.
You said this better or more eloquently than I'm going to, but essentially what you were saying is that if we had a meeting like we're having, and the committee decided that, of course, not a recommendation, but just make note of something that perhaps got brought up several times throughout when we were doing our public engagement. So just to build off what MLA Hansen had said, what does it look like? What's the process? Would it just be a motion from the floor or would it be a majority of the committee saying, yes, we would all like that, and can we do that here and now?
Please proceed, Ms. Robert.
The committee can do it by consensus, or if they don't feel they maybe have consensus, certainly a motion from the floor could come forward. Typically, it's a consensus-based thing, and I mean, I suppose, you've already kind of gone beyond your deliberations. If you want to go back, I suppose you could make a motion to go back to that item on the agenda and discuss whether you'd accept a motion or have a discussion to say we want to add this to the report. That's up to the committee to decide.
Emily Milliken, follow up. Go ahead.
I would like to make a motion from the floor to go back to have such a discussion.
I will just briefly review to make sure I have this process perfectly done, and just make sure I get this correct before we proceed. I'm just going to pause briefly. So at this point in time, there seems to be a bit of consensus on this, that you want to push back to get this on record. And it's an administrative motion request, which I will allow at this time. So please, Emily Hansen, go ahead at this time.
Yeah, so just for clarity, because I understand that possibly you weren't at all the meetings.
Oh, sorry,
I'm sorry.
You did make the motion. Oh, sorry, let me briefly. That's a better understanding. I apologize to committee members. So the motion as proposed by MLA Milliken, of course, we don't need approval to hear it. So please give your rationale to the reasoning on your motion, and then we'll go to discussion and voting on this motion.
Yeah, very briefly, the rationale is because I think Member Hanson brought up something that I think maybe we should try to ensure is within the report, but not necessarily a recommendation per se. So that's the rationale.
Is there any further committee members that would like to speak to the motion to Milliken to move back into the deliberations portion? Seeing and hearing none, I will put it to a vote. All those in person in favor of this motion, please say aye. All those opposed to this motion in person, please say nay. Online, all those in favor, please say aye. Aye. Online, all those opposed, please say nay. That motion is carried. Please go ahead, Emily Hanson, and then I think I saw Emily Schmidt. Is that correct? Oh, sorry, Emily Hanson, go ahead.
Okay, so thanks. So just the rationale behind it, because we did hear it very consistently at 3 of the 6 meetings, and it was about access to public lands. And some of the rationale was that hunters felt, especially hunters and some people that wanted to recreate on public lands, felt that some of the leaseholders of public lands were unfairly blocking them from access. So it's just a matter of asking Environment and Parks to consistently enforce the regulations that already exist under the Public Lands Act and the Wildlife Act. Because these are two areas that folks were quite adamant about. And it's simply about fair and equal access to public lands by all Albertans. And that's all they were asking for. And like I say, I have brought it up as a question in the House. It's something that we heard quite consistently. I know it doesn't fall within the mandate as it was laid out to this committee, but being that we heard it so significantly and consistently, I just thought it would be something that we could discuss briefly and have it so that it's part of the report.
Thank you, Emily Hanson. I will just go back to Ms. Robert for comments. Please go ahead.
Thank you, Mr. Chair. So just so I'm clear, what you're proposing and hoping to get support for from the committee is to include some contextual information in the report about your thoughts and beliefs on access to public lands as you've described.
Yes, yeah, just equal, fair access to all Albertans to the public lands, and just under the law of what's already there in the Wildlife Act and the Public Lands Act. So.
Okay, thank you.
Thank you, Ms. Robert. Is there any additional comments in relation to this? I am going to go to the committee too to make sure that we do have consensus on this, Emily Hanson, if that's fair. Want to make sure that we do have fair consensus on having this included as a part of the deliberations portion of the committee. So is there any other comments in relation to this? Emily Schmidt.
Yeah, thank you, Mr. Chair. So while it's unclear to me what Mr. Hanson is asking for specifically to be in the report, it's just a reminder to the committee that neither the Public Lands Act nor the Wildlife Act are technically within the scope of the committee. And so I hope that the report sticks to the scope and that whatever references that Mr. Hanson is looking for with respect to the issue of hunting on public land, which I will agree is something that is a problem, but again, is not within the scope. I certainly hope that the report doesn't go outside of the scope, because we've been very careful about sticking to the scope that the committee has given itself.
And I will briefly pause here too after some additional comments from the clerk, is that this could potentially be a part of a minority report submitted to as well. So next I have speaking Emily Van Dyken. Please go ahead.
Yeah, thank you, Chair. And I'm just looking at the committee's mandate, and I understand the concern, but I can't see that I can't see that it falls within our mandate. It's not a real property concern. It is an access concern with regards to Crown land. So I would have to agree that it falls outside of the scope of the duties of this committee, and should be addressed through different means.
Anybody additional that wants to speak to this? Emily Hanson, go ahead.
I will, and thank you, Chair, and thank you, Mr. Van Dyken and Mr. Schmidt, for your comments. And I do agree 100% with your comments, but it was something that we did hear quite consistently. That's why I didn't bring it forward as a motion, because I knew it would be ruled out of order, but I just wanted to put on the record that it was something that we heard quite avidly by a lot of folks in their presentation. So it was just, want to recognize the folks that came forward, took the time out of their days to come and present to our committees.
And seeing as how we're getting a little bit of mixed impressions on this right now, of course, to have this included as a part of the deliberations, I would need to see some strong consensus to have this included at this time. So if I will actually call the question on this, all those in favor in person, sorry, Emily Schmidt, go ahead.
Sorry, Mr. Chair, just for clarity, what exactly are we voting on?
Oh, so there is. No. You're good? Okay. Anything additional? We're now moving back into report of the Committee of the Assembly. We were with Ms. Robert on questions on the report. Now I would also note that the committee may wish to streamline the process and avoid another meeting by authorizing the chair and deputy chair to approve the draft report after it has been made available for committee members to review. What are the members' thoughts on this issue? Emily Hanson?
I would make a motion to that effect if that's required.
Yes, we do. There is a draft motion here that you can review, and if it fits what your intentions are, please go ahead.
Mr. Hanson, to move that the Select Special Committee on Real Property Rights direct research services to prepare a draft report on the committee's review pursuant to Government Motion 69 containing the recommendations approved by the committee, and authorize the chair and deputy chair to approve the report after making it available to committee members for review.
Is there any additional comments or questions as to the motion moved by Emily Hanson? Seeing and hearing none, all those in favor in person of the motion as proposed, please say aye. Aye. All those in person opposed, please say nay. All those online in favor, please say aye.
Aye.
Aye. All those online opposed, please say nay. That motion is carried. I'll note that minority reports should be submitted to the committee clerk no later than noon on June 17th, so they can be appended to the committee's report. And I'm going to just comment now, of course, on the approval of the final minutes after deliberations. Honorable members, as this may well be the final meeting of this committee, the practice in similar select special committees has been to authorize the chair to approve the minutes of the final meeting after members have had an opportunity to review them for the records of the assembly. I would like to open the floor to discussion on this matter. And if there is agreement to this, we do have a proposed motion that could be moved. Emily Rutherford, please go ahead.
I will move that motion if there's one prepared. Look at that. I move that the Select Special Committee on Real Property Rights authorize the chair to approve the minutes of the May 26, 2022 meeting of the committee after they have been circulated to committee members for review.
Excellent. Is there any questions, comments? Seeing and hearing none, all those in favor of the motion as proposed in person, please say aye. Aye. All those opposed in person, please say nay. Online, all those in favor, please say aye.
Aye.
Online,
Aye.
Online, all those opposed, please say nay. Thank you. That motion is carried. Moving on to 6, other business. Are there any other items that the members would like to discuss at this time? Seeing and hearing none. Date of next meeting. Having completed our deliberations and provided instructions for drafting the final report of the committee, once the report is provided to the Assembly, that will conclude the mandate of this committee. Therefore, no further meetings of the committee are anticipated. Moving on to adjournment. If there's nothing else for the committee's consideration, I'll call on a motion to adjourn. I see MLA Rutherford. Please go ahead.
Thank you, Mr. Chair. Given that there is a very pressing Oilers game this evening, I move that we adjourn.
All those in person in favor of adjournment, please say aye. Aye. All those in person opposed, please say nay. All those online in favor, please say aye.
Aye.
All those online opposed, please say nay. That motion is carried. Thank you, everyone. This meeting is adjourned.
Thank you, Chair. Well done.